Hi everyone, welcome to Practitia Legal. I am Madhuri. This is the new initiative taken by Practitia Legal to bring legal lectures in various languages. I am here to bring legal lectures in the language of Telugu. So, Telugu అని చెప్పి మొత్తం తెలుగులో ఉండదు. It is a mix of English and Telugu. Going into the concepts that are under Law of Torts in detail, first let us try to understand what is the term tort mean. First, tort అంటే ఏంటి అనేది చూద్దాం. Tort is a word that is derived from Latin term tortum. So tortum అంటే ఏంటి? To twist. And English, according to English, tort is equal to wrong. Now let's discuss about the definition of the tort. There is no as such a single. Now let's discuss about the definition of the tort. So there is no as such a single definition regarding the tort. So there are various definitions given by various legal philosophers. So let's discuss one by one. First, according to section 2M of Limitation Act, it states that tort means a civil wrong which is not exclusively a breach of contract or a breach of trust. So according to Solomon, tort is again a civil wrong for which remedy is common law action for unliquidated damages. So don't get tensed of hearing this unliquidated damages. So in the coming lectures మనము unliquidated damages అంటే ఏంటి, ఎందుకు this is under torts, so this is why unliquidated damages is covered under torts అనేది చూద్దాం. And which is not exclusively the breach of contract or breach of trust. So this is the definition given by Solomon. Now let's discuss about the definition given by Winfield. So Winfield says that tortious liability arises from the breach of duty fixed by law, and this duty is towards the persons generally, and its breach is redressable by the action of unliquidated damages. So discuss about the definition of tort regarding another legal philosopher known as Fraser. So according to Fraser, tort is an infringement of right in rem of a private individual giving a right of compensation at the suit of the injured party. So first let's discuss about this right in rem. Asal right in rem ante enti? So this is the legal right that a person has against the whole world rather than against the specific person or group. So this means that a person can assert the right against anyone who infringes it. So whoever infringes his right, that is a legal right, he can go and file a suit and take an action or bring an action against the person who infringes his legal right. So this is known as right in rem. So as a whole, tort is a civil wrong, often involves infringement of right in rem. So this is all about the definition given by the Fraser. We are done with the definitions. Now let's discuss few fundamentals or important points that need to be known by everyone while studying law of torts. So these are all the important points that need to be known by everyone. So let's take an example for better understanding. There are two persons, Ajay and Rajesh. So Ajay has to perform certain duty towards Rajesh. So he is under an obligation to perform his duty towards Rajesh, but Ajay fails to perform his duty towards Rajesh. So now this leads to violation of legal right of whom? Of Rajesh by Ajay. So here there is a duty on Ajay that he need to perform towards Rajesh, but Ajay fails to perform his duty, which leads to the legal injury of Rajesh. So here the legal injury is violation of his legal right. So now we can say that Ajay is an tortfeasor. Tortfeasor means he is a person who committed tort. As he violated the legal right, we can consider him as tortfeasor or wrongdoer. So now Rajesh is considered as plaintiff or injured person, as he has suffered injury or harm due to the violation of his legal right by the Ajay. So here Ajay has infringed legal right of Rajesh by not performing his duty towards Rajesh. So this is the whole scenario which explains all these important points. So now here is the tortfeasor and here is the plaintiff. Now this is the scenario. Now there is a legal injury that has happened to Rajesh. Now he wants some relief. So what is the relief that he can get from Ajay? So now let's discuss in detail about the injury and the compensation or the relief under law of torts. So under law of torts, the compensation or the relief that a person or aggrieved person or the sufferer or the injured party can get is unliquidated damages. So the compensation will be in the form of unliquidated damages. Unliquidated damages means the compensation is fixed by court. The compensation is fixed by the court, not by the parties. If it is fixed by the parties, then it comes under the contract, where the contract itself has all the duties, rights, compensations, reliefs, and the disputes and the procedure of the dispute and all the legal mechanisms that need to be followed when the dispute arises. All the things will be mentioned in the contract itself. Whereas under law of torts, there is no as such agreement. The part dispute arises or when the person commits a civil wrong or when the person causes legal injury to another person, the suffered person or the aggrieved person will go and approach to the court and file a suit there to get compensation or to get a relief. So under law of torts, the relief is monetary compensation, so which is fixed by court, not by the parties. Even though there is even though in person. So this is all about the compensation. This is all about the compensation that is involved under law of torts. So this is all about the compensation that is involved under law of torts. So the next important point is tort is an uncodified law. So there is no sections, subclauses, anything as such that we see in BNS or BNSS where it contains sections, subsections, etc. So tort is an uncodified law which does not contain any sections. So as a whole we can say that there is absence of contract between the parties. So under law of torts, the concept of contract is not discussed. So this is all about the important points that need to be remembered by everyone while studying law of. So these are all the important points that need to be known by everyone while studying law of torts. So now let's discuss about the difference between crime and tort. So crime is a public wrong, tort is a private wrong. So violation of public right. So in crime there is a violation of public right and which causes harm to the society, whereas when we come to tort, there is only harm to a specific individual. There is no such harm to the public at large. So elements may vary from crime to crime. So let's take an example, like there is a theft or extortion or a murder. So the elements vary from crime to crime. In tort, the elements are determined. So there is a specific list of elements that are covered under Law of Torts. So the proceedings against the accused will be brought by the state itself under crime. The injured party himself files a suit in the court for his redressal, like for his compensation or for his relief. There is no place for settlement in crime. So there is a place for settlement in the Law of Torts. So if both the parties agree to come to a settlement, they can. There is a possibility under Law of Torts for a settlement, whereas under crime there is no such possibility for the parties. So the remedy is only punishment. Here the remedy is monetary compensation. So here the person will be arrested, imprisoned. So there is no such thing that is covered under Law of Torts like arresting, imprisonment, etc. Here the monetary compensation is the remedy or the relief that can be obtained by the injured party from the wrongdoer. So this is all about the crime and the tort difference. So this is all about the difference between crime and tort. About tort and breach of contract. Under torts, breach of duty is imposed by law. And under breach of contracts, the duty is imposed by parties. There is no agreement in tort. So manaki tort, there is no chance of agreement. Then only the unliquidated damages are coming into play in resolving the dispute and providing the relief. Whereas when we consider the breach of contract, the damage is liquidated damage, means the compensation is fixed by parties. Here the compensation is fixed by court of law. There is no such thing as agreement or contract under tort. So tort has nothing to do with the agreement or contract. So under breach of contract, while the parties are entering into the contract, the obligations, rights, duties, compensation, the reliefs, the dispute resolving mechanisms, all the things will be mentioned already while entering into the contract by the parties. So they all read it and they sign it. So after signing it, they'll enter into the contract, and if there is any violation of any provision by any of the parties, they approach to the court to enforce their contract. According to their contract, the court provides the relief. So in tort, there is no such thing as predefined provisions. So based on the degree of injury that a person has caused to the injured person, the court decides the compensation. So that there the unliquidated, so that is why the unliquidated damages are discussed under torts. So as a whole, we can say that all civil wrongs are not torts. A tort is a specific type of civil wrong, but not all civil wrongs fit into the category of tort. So we cannot say all civil wrongs are torts. So tort is a specific civil wrong that is discussed. As a whole, we can say that all civil wrongs are not torts. Tort is a specific type of civil wrong. So breaching of contract is also a civil wrong, but it does not come under Law of Torts. So if any dispute arises between the two parties who entered into a contract already, the dispute mechanism or the relief will not be granted according to the Law of Torts. So it will be governed according to the Indian Contract Act 1872. So the line or the meaning of this sentence is this. Now let's discuss about the essentials of torts. So these are all the essentials of torts. So the first one is wrongful act. So this wrongful act is caused by wrongdoer or tortfeasor. So he causes legal damage to plaintiff, and legal remedy is available to plaintiff in the form of unliquidated damages. This is the whole thing that is discussed under Law of Torts. So here again, unliquidated damages means the compensation will be decided by the court. So to constitute a tort, these two conditions should be fulfilled. Then only a person is held liable under law. So to constitute a tort, these two conditions must be fulfilled. Then only a person is considered as a wrongdoer or tortfeasor under Law of Torts. So he would be held liable to compensate to the other person for causing legal injury. So first one is there must be some act or omission on the part of the defendant. Here the defendant is again wrongdoer or tortfeasor. So he is the one who commits legal injury to the other person. So the other person is obviously the plaintiff. So what is the legal damage that the defendant causes is violation of legal right of the plaintiff. So this is the two conditions, or these are all the two conditions that need to be there, or so these are all the two conditions that constitute a tort. Only then a person is held liable under Law of Tort. Dispute has two important maxims that are involved under Law of Torts. So first one vachesi injuria sine damnum. The second one is damnum sine injuria. So first let's discuss about the meaning of this maxim. So injuria means injury. So according to Law of Torts, infringement of legal right is considered as injuria. Normally it is injury, but according to Law of Torts, it is considered as infringement of legal right. So sine means without, damnum means damage. So now let's discuss about the second one. Damnum means damage, sine means without, injuria means obviously the infringement of legal right under Law of Torts. So this is all about the two important maxims. Let's discuss in detail about these maxims. Discuss in detail about these two important maxims. First one is injuria sine damnum. Injuria sine damnum means infringement of legal right without causing damage to plaintiff. So here the plaintiff does not suffer or does not get any financial loss. He does not suffer from any financial loss. Only the legal damage that is faced by the plaintiff is his legal right will get infringed. Who will infringe? Obviously the wrongdoer will infringe the legal right of the plaintiff. So in damnum sine injuria, damage is caused without infringement of legal right to the plaintiff. So here the damage is under damnum sine injuria, the plaintiff suffers financial loss. There is no violation of legal right of plaintiff. So we can state that injuria sine damnum, no financial loss, is only violation of legal right, violation of legal right of plaintiff by the defendant or wrongdoer or tortfeasor. So in damnum sine injuria, the plaintiff suffers from financial loss. There is no violation of legal right. So this is the basic difference between these two maxims, where in injuria sine damnum there is only infringement of legal right of the plaintiff. There is no financial loss. Whereas in damnum sine injuria, the plaintiff suffers from financial damage without infringement of his legal right. The wrongdoer causes financial loss to the plaintiff, whereas the wrongdoer does not cause or violate the legal right of a plaintiff. Whereas in injuria sine damnum, the wrongdoer does not cause any financial loss, but he violates the legal right of the plaintiff. Discuss these two maxims with an example or with the help of a case law. So the name of the case law is Ashby versus White. So here Ashby vachi plaintiff, White vachi defendant or wrongdoer or tortfeasor. So the facts of the case are, Ashby is a qualified voter, but he was not allowed to vote. Who did not allow? White did not allow Ashby to enforce his right to vote. So obviously the Ashby is the aggrieved party. He suffered because he was not allowed to vote. He approached the court and the court held that right to vote was an actionable wrong. Even though the voter did not suffer any financial loss as such, his right to vote is infringed by White. Therefore, the White should be held liable to compensate for the loss he caused to the Ashby. So, according to this maxim, the right to vote of Ashby is violated by White. Now, for this legal injury that is caused by the Ashby. Now, for this legal injury which is caused to the Ashby by the White is held liable to compensate for the legal injury that he has caused to the Ashby. So, White will be held liable to compensate to Ashby. White will compensate to Ashby as he has caused legal injury to Ashby. So there is no financial, even though there is no financial loss faced by the Ashby, the legal right of the Ashby is injured, so that the court held that Mere violation of legal right can be basis for legal action. Even though there is no as such financial loss that is suffered by the Ashbay, there is a violation of legal right. That is why, being the reason, the white is held liable to compensate for the legal injury caused to the Ashbay. Case law. So according to this maxim and the case law, if we consider, there is a financial loss to the grammar school. There is no infringement of right. To grammar school. So the grammar school also has the right, and the newly established school, the management of that newly established school also have equal legal right to establish a school and run as the grammar school has. So this is the case law that comes under, or that fits under, damnum sine injuria, where it states that damages are caused without infringement of legal right, where financial loss is suffered by the grammar school and there is no as such their rights are infringed. Let's discuss about the general defenses that are available under tort. So these are the defenses under which the wrongdoers can defend themselves to avoid liability. What liability? To compensate for the injuries that they have caused to the plaintiff. So by using these defenses, the wrongdoer can avoid the liability to compensate. So he can escape from paying compensation to the injured party. So these are the defenses, few defenses. First one is volenti non fit injuria, plaintiff the wrongdoer, where the plaintiff itself becomes the wrongdoer. Act of God, private defense, mistake, necessity, inevitable accident, and statutory authority. Case law under this volenti non fit injuria. The name of the case law is Hall versus Brookland. The facts of the case are, during a car race at a Brookland, a car collided and it was flung into the spectators area, and Hall got injured due to that accident. Hall went and sued them. Who? Auto Racing Club. So Hall went and filed a suit in the court against the Brookland Auto Racing Club, asking for compensation. So the court held that Hall will not be entitled to get compensation or to seek compensation, as he has given his consent by knowing the nature of the act. So here Hall has given his consent by knowing the nature of the act he is going to do. He would not be entitled to seek compensation from the Auto Racing Club. And court also held that this was an accident which is considered as an extreme event, and the club was not held liable to pay compensation for the injuries caused to the Hall. Plaintiff the wrongdoer. So under this defense, the defendant, when he proves that the plaintiff, he himself is responsible for the legal injuries that he has suffered. So when the defendant proves that the damages caused to the plaintiff is due to the plaintiff's own fault, then only the defendant will be not held to compensate to the damages caused to the plaintiff. In this case, the plaintiff is injured due to his own wrong, and the defendant would not be held liable to compensate for the injuries caused to the plaintiff, because in this case the plaintiff is suffered from the legal injury due to his own fault, not by the defendant's action. The plaintiff is not entitled to seek compensation.